IVM.
Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to another episode of Police Chowki. In this episode, we are going to delve into the world of criminal investigations by police in India, a process that is complex and very critical. Any crime is an assault on the rule of law. So, the constitutional duty of the police is not only to prevent crime, but also to ensure that those breaking the law are prosecuted as per due process and punished. And of course, the victims must be assured of justice. This is a basic but fundamental role of the police in any democracy. In today's episode, I'll be speaking to Mr. Ahmad about laws, crimes, and justice. We'll be exploring the process the police follow once a crime comes to light, till the final act of criminal prosecution and conviction of the guilty. Along with this, we'll also be looking at the rules-based framework which governs the police powers, responsibilities, and duties in carrying out the functions of a criminal investigation. We'll also look at some of the high-profile cases and the challenges faced by our police forces in doing their job. And I've invited Mr. Ahmad to also give some insights from the experience he has had on ground during criminal investigations. A key aspect of our discussion will also be on the rights of the accused, a topic that is often at the heart of debates about justice and fairness in our criminal justice system. We'll also delve into the issues surrounding police accountability as far as crime investigation is concerned. Before that, I wish to extend a very warm welcome to Mr. Javeed Ahmad to the show.
Good afternoon, Shri. Nice to be back on this podcast.
Thank you for joining me for what promises to be a very interesting episode on criminal investigation by the police. As we can imagine, the process itself is very complex. It involves numerous stages from the initial reporting of a crime to the final resolution in the form of a conviction, and maybe even up till all the appeals in a particular case are exhausted and convict is finally punished. So let us begin with the basics, right? Let us begin with the site of crime. So once there is a site of crime which has been discovered, I want to know from you, how does the police machinery swing into the action? What exactly happens at a crime site? What kind of evidence is collected? Where do the forensics team come in? So if you could, begin by guiding us through all of this.
Yeah, when any crime incident is reported, typically the information comes in urban areas, it comes over the telephone to the control room. In rural areas, even now, there are some percentage of cases wherein the complainant comes physically to the police station. But whatever the mode of information receipt, the first thing that police is expected to do and does is that they proceed to the scene of crime and secure it. By securing, I mean that the access of unwanted or unnecessary persons to the scene of crime is restricted or even stopped fully. The intention behind is that whatever evidences can be collected from the scene of crime or the reconstruction of the events as they took place at the scene of crime has to be done in the most polluted or undisturbed manner as is possible. This is a field of police work that is not appreciated. In fact, in the Indian circumstances, there's always this eagerness among neighbors and journalists and others to try and force themselves into the room or the area where the incident has taken place. And in the process, inadvertently, they could be, destroying or tampering or, causing damage to evidence that may be available. The evidence that is available could be of various types. It could be physical evidence, for example, a bullet casing that has been fired. Obviously, in a case of murder, for example, there would be the body of the person who's been murdered. There would be splashes of blood on the floor, on the wall. The pattern of the splash of the blood itself is a good indicator of how the incident has happened. There could be other body fluids. It could be a handkerchief which has the sweat or the other body fluids. It could be clothes or many other or fingerprints or footprints. There are a number of physical and biological pieces of evidence that can be collected by a expert scene of crime. Thankfully, the scene of crime investigation is starting to become much more professional now in India than it was in the years gone by. And my mind goes to the famous Arashi murder case a decade and a half ago, where the initial response of the scene of crime investigator was left a lot to be desired, with the result that very important evidence was lost and it was ignored, and it meant that a lot of time, almost 36 hours of time, was wasted pursuing a lead which should not have been pursued at all. If you recall, the allegation initially, the apprehension initially was that the servant of the poor girl had committed the crime, and the police kept searching right up to the Nepal border, trying to apprehend this person who allegedly could have committed the crime. As it turned out, the dead body of the servant was found on the roof of the apartment where the incident had happened. Now, this is one of the most brazen and blatant examples of poor scene of crime investigation. So, to wrap it up, I mean, the scene of investigation holds many, many clues about what has happened. Some of those clues are very obvious, but there are many which a seasoned and observant investigator can find from the scene of crime. So it's very important that the scene of crime is not disturbed, unnecessary entry into the protected area is not allowed, and the people and the public also stay away from it and keep their inquisitiveness under check.
Right. And could you also maybe throw a bit of light on the procedural aspects of this? Like, how is evidence, once it's found, how is it collected, stored, how is it marked, what is a panchnama, and how does the whole thing play out?
Yes, very relevant point that you raised, because evidence, when it is collected, has to be, there's this thing called the chain of custody. When any evidence is collected, then it has to be, first, the investigator has to record where it has been found. Then he has to define it in his records about what he has found it. The witness has to sign or record something that, yes, this particular thing has been found at such and such place. The next step is of packing it. If it is not packed in the correct kind of packaging, then the chances are that the evidence itself will get destroyed or contaminated in the process of packing and transporting. For example, if there is blood, there has to be a packet or something which is clean, sanitized. Otherwise, if it is contaminated and blood is put inside it, the results may not be as you want them to be. So, packaging is very important. And then the chain of custody requires that the process or the means through which it is sent to the lab for examination is also defined and very certain, so that in the court, the defense is not able to, pick holes into the genuineness of the collection and the examination process of the evidence that has been collected.
Right. And I want to know a little bit more about the quality of the investigation itself, right? So you said that it has improved over time. It has become more professional. It's become more sophisticated. So I want to know, how does it work? To what extent has it happened? Because even today, it seems like, there are many instances where the police just rounds up the suspect, subjects them to what is euphemistically called the third degree by keeping them overnight in police stations and, actually make the accused confess and lead them to the evidence, and, the case is closed. Is that how it still happens? Or, to what extent has it become more professional? What extent has it become more sophisticated?
Yeah, because forensic capabilities of the Indian police has improved over the last maybe 2 decades or more. The investigating officers have now realized that using those forensic evidences has much more value in the court than the rough and ready methods that they may have been using in the past. For example, the Indian police now in all states has very good capacity for analyzing cell phone data. Now, availability of cell phones in India is very, very wide. As we all know, criminals almost always are using cell phones to communicate and to pass on information, etc. So, the analysis of cell phone data, of call records, etc., is something that the Indian police has become rather adept in. And even though it may be seen from outside that the rough and ready method is what is being deployed, behind the picking up of individuals there is a lot of scientific work which is being done by specialized units who are able to shortlist the number of suspects from N to X. So at the end of it, maybe there are 2, 3, 4 suspects, and they are subjected to intensive interrogation, wherein their statements are matched against the statement of their possible accomplices and the information that is gathered from their cell phone records about their presence or the fact that they have spoken to someone and all that. So I think it may be slightly cynical to believe that the rough and ready method of the past is still the normal practice. Maybe there is still some element of rough and ready. I would not deny that. But thankfully, it is less now than what it was in the years gone by.
Right. And what I found interesting from your response was that the courts are insisting on a higher quality and higher threshold of evidence, which in turn is forcing the police's hands to adopt more serious investigative methods to collect evidence in a more qualitative manner, so that the conviction actually holds up and the court does not end up getting discharged. So, is this what it's happening? Is this giving police the incentives to change?
Yes, that is one of the triggers. You see, the defense lawyers are now better informed in the sense that they are more aware of the technology and how technology can be used to puncture holes into the prosecution story. So the prosecution also has to come up with a story that does not have loopholes. So more alert defense necessitates improvement in the prosecution coming up with better evidence, and evidence that is can be defended in the court, evidence that is admissible in the court, and evidence that does not have loopholes.
Thank you for listening to All Things Policy. We'll be right back after a short break. I would like to open up a small discussion on something which is significant and often overlooked, which is the rights of the accused within the criminal justice system, right? So, a cardinal principle of rule of law, as everybody knows, is innocent until proven guilty. Right, and a long process of human civilization and development of rights jurisprudence over centuries has led us here. From the times where people were hanged on mere suspicion of committing the offense, today we have evolved a principle which says until a person is proven guilty beyond a certain standard of doubt, you cannot sort of throw them in jail and punish them. So, along with this right, there are many other rights that an accused enjoys under our constitutional and legal setups. These include the right against self-incrimination. That means that the police can't force him to give evidence against himself. There are rights which say that after arrest, an accused has to be produced before the magistrate within 24 hours. And of course, the accused also enjoy the right to legal representation, starting from the police custody till all their appeals are exhausted in the court of law. So all these rights exist in paper, but still the fact remains that Indian police is quite notorious for violating the rights of the accused. And we already have tons of data on police torture, custodial violence. Even today, thousands of people die in police custody, which has forced courts to intervene and talk about installing CCTV cameras in all police stations, which has not been complied with. So where have we gone wrong? And in fact, what is more troubling for me is that society sometimes supports these acts of police, which violates the rights of individuals. And the logic is something like, either you want justice or you'll end up, supporting the accused, right? Which is actually the wrong way to put it. The whole idea is the burden is on the state to prove the case beyond the threshold of doubt while respecting the rights of the accused and also ensuring justice to the victims. So where do you think we have gone wrong, both as a society and as the police? Why is it that the police is so shy of respecting rights of the accused?
The need for following the rule of law and the need for following the due process of law is something that is enshrined in our constitution, in its fundamental rights chapter. So to believe that any police force can, on the long term, continue to flout that or ignore that would be foolhardy. There is no choice for the police but to follow the law of the land. And the law of the land is that a person is innocent until he is proven guilty, as you said. It also is that whatever action is being taken by the prosecution or by the law enforcement agency has to be within the four corners of law as procedure defined by law. That is what the Constitution says. The courts have been very vocal on this. There is a very famous judgment called the D.K. Basu case, which spells out all the rights of a person who has been detained or arrested, and those are expected to be followed by the police at every instance where arrest is made. I remember about 20, 25 years ago when this judgment had come, every police station had a big billboard in which all the obligations on the police after a person has been arrested had been written in local language, and it was hung office of the police station in every thana across UP, and I would dare say every thana across this country. Those obligations include include the requirement that the person who's arresting should have his name tag on his uniform. It includes the requirement of informing a kith or kin of the person being arrested that so and so has been arrested, informing the local police control room about where that arrested person is being detained. Arrested person has the right to meet a lawyer of his or her choice, and some other instructions which were laid out. And I emphasize the point on paper. All these obligations that the police, that the DK Basu judgment has obligated on the police are being followed. Now, I am emphasizing point on paper because ultimately, it's a question of trust. All these functions will be done. The records will show that all these functions have been done. A perfunctory, telephone call or an SMS will be sent to the kith and kin or the, person interested in the arrested individual. All that will be done. But once again, we go back to that ethics thing that we had talked about, that the ethical moorings of the police have to be strong enough to not cut corners when they are dealing with individuals and the human rights and the civil rights of the individuals who are in custody. Unfortunately, the desire to give quick results can often lead police to cut corners. At times, investigation is done with some extraneous considerations, and that may result in corners being cut, which are inexcusable situations.
Right. And I want to also extend this discussion to the issue surrounding grant of bail, right? Now, of course, under law, there are two kinds of, just for the benefit of our audience, there are two kinds of offenses, bailable and non-bailable. Bailable means you can actually put forth a bond before the arresting officer and get bail as a matter of right. In much more serious offenses, these are called the non-bailable category. And here, only the magistrate can grant you the bail if certain conditions are satisfied. So, apart from this, the fact remains that most of the prisoners in our country are under trials. Nearly 2/3 of them are under trials, in the sense they have not been convicted by courts of law, they're just waiting trial. But the fact is they're not getting bail, they're not making out of the jail on bail. Then we have a long series of court cases which say that, bail is the rule and jail is the exception and so on. But the fact of the matter is we have a lot of under trials who don't have bail, and the police and the investigating authorities are also not bail friendly, in the sense they always, on most occasions, end up opposing grant of bail to the accused. So could you maybe explain what is going on here as to why do the police regularly oppose the grant of bail, and why is it that we are not being able to fix the problem of under trials looked at from this angle?
Look, the blame for the number of under trials going up every day has to be shared by the police with the judiciary, because even while the police may be opposing bail in a large number of cases, rather in large majority of the cases, ultimately it is the judiciary which goes along with the prayer of the police for not granting of bail, and makes the person who's under trial stay in jail rather than be given bail. The Supreme Court has, in this famous case called Joginder Kumar versus State of UP, they have very clearly laid out that there are certain conditions under which bail is to be refused. Those conditions include the possibility that the person will commit crime again, or that he will tamper with the evidence or cause the evidence to be tampered, or that he will abscond, or that there are reasons to believe that he is not going to subject himself to the law enforcement agencies. Now, despite these very clear-cut instructions, ultimately it becomes a question of the philosophy of judges and the judiciary about why they are not ready to grant bail. In fact, a very recent development about a month ago, which was covered in the newspapers, there was this matter in the Lucknow court of a very routine case in which bail had been refused by the session court. The Supreme Court took notice of that and pulled up the judge and sent him from his posting to a training academy to study law once again, and passed very strong orders saying that everyone should understand that bail is not something that has to be refused as a routine matter. Rather, there are conditions under which bail has to be given. And this philosophy that is presently, on the ascendance within the judiciary of not granting bail, this needs to be countered. So, this kind of very proactive intervention by the Honorable Supreme Court, I believe, and this incident that I'm talking about, 4 weeks or 5 weeks old, which was covered very widely in the newspapers, this kind of strong proactive action by the court is going to make a huge difference. Why the police continues to oppose bail is the other part of your question. I have a feeling, I may be wrong, but my understanding is that because the police has this feeling or this belief that till a person is in jail, he is being punished for whatever offense he has done. And once he is out on bail, the whole trial process is going to take such a long time that ultimately he is not going to get punished. And that seems to be in the minds of the police persons and the police officials, the justification, if I may call it that, for routinely opposing bail. How justified this justification is, I would leave that to your imagination and to your judgment.
I think that's a very interesting point that you make, and I think large parts of the public also maybe echo the police on this front, because the belief is that the trial takes forever to complete. This person will get bail, he'll continue on the roaming around the streets and probably commit the same offense again, right? So bail has somehow emerged in the minds of public and maybe even the police, like you pointed out, that keeping somebody under custody and not granting him bail is the best justice that we can get given our current system, right? And this, I think, is a good point for us to look at criminal prosecution and trials. So I want to know from you, could you maybe chart out the entire process of prosecution, assuming that the part about collection of evidence is done, investigation is done, the police has decided that okay, we have enough evidence to prosecute this guy. So from that point, what is the journey? So what happens next? How do criminal prosecutions, court of law, play out? And maybe you can take 1-2 examples of cases that you have seen or overseen, and take us through this whole aspect.
Okay, but before I go into the prosecution, let me quickly, run through the process of investigation, which is very important. Once the case is registered and the scene of crime, as we discussed, has been examined, the process of investigation starts. The process of investigation includes calling witnesses, for which the police is authorized under Section 160 of the CRPC, taking their statements under Section 161 of the CRPC. The important thing here to mention is that the police cannot take a signed statement of any person or witness during the course of the investigation. Any statement made to the police cannot be, no police officer can make you sign that statement that you have made. That's important because the public often, feel that the police will ask them for a signed statement. Now, the process of investigation obviously involves collecting all the evidence that is relevant to the case, and depending on the kind of case, the police has 60 days or 90 days, depending on the kind of case that is being investigated, to file a charge sheet or a final report about the case, in which they delineate the evidence and then point out who are the individuals who are responsible for the commission of that particular offense. Normally, 60 days and 90 days is not sufficient in important cases, and the police then has to take more time by making a request to the court. Now, what happens is that if within 90 days the case has not been finalized, then the person who has been arrested in that case has the right to apply for and get bail. So after 90 days, he gets bail as a matter of right. Or if it's 60 days, then 60 days. So the filing of the charge sheet within those 90 days or 60 days is important from that point of view also. Once the case is charge sheeted, ends in a final report, then the story ends. But if a charge sheet is filed against an individual or more than one individual, then the charge sheet is filed before the concerned session judge, who then, the first stage is called committing, where the magistrate commits the case to the court where the trial is to be held. Then the process of supplying documents to the persons who have been charge sheeted starts. It's called Section 207 of the CRPC, where all the documents that the police or the prosecution intends to rely upon to initiate the trial against the person is made available to him. This can take months because, especially in document-based cases, for example, in the CBI, I remember we were investigating the fodder scam case in Bihar. The documents that we supplied to the individuals had to be transported on trucks because there were about 12 or 13 individuals who had been charge sheeted, and each of them had to be given documents which were like 3-4 trunks full. And, photocopying them, marking them, tagging them, then making a set for each of the individuals is a huge exercise. In those times, the photocopiers were not, fast enough to churn out so many copies. So, it was a huge logistical thing just to supply documents. That takes a lot of time. Then once it is given to the defense lawyer, he will raise objections that page 19, page 123 and page 394, they are not legible. Please give me another copy. So these games are played. And time flies because, all this. Once all this work is done, then the witnesses are called. Now, unfortunately, the courts are so overburdened that they will call witnesses. The witness will come maybe from afar. I know of instances where retired senior officers have come on a summon from Madras or Chennai to Lucknow or to Delhi, presented themselves before the court, and the court has said that we don't have time today, you go back. Now, this man is 70 years old, 75 years old. He spent a lot of money, time coming, and he says that I cannot come again, for the next 1 month or 2 months. So that is why trials get delayed. The courts are overburdened. Judges don't have that kind of management skills where they call people just of the right number so that they are able to handle each defense witness or prosecution witness who comes. So all this takes time, and that is why there are instances where criminal trials, especially in cases of corruption and bank frauds, can take 10 years, 15 years to be completed. Because the more influential the accused, the better lawyers he will get. And the better lawyers are always able to find loopholes in the prosecution game and the prosecution story, and they will keep playing for time because they know that with time, a lot of other witnesses will die, or they will forget, or they will, just lose interest. All kinds of things which are often out of the control of the person involved will happen, and benefit of doubt will go to the accused. So the processes that are prescribed in the Indian law allow for this kind of dragging of dates, dragging of time. And I am very happy that the government is now looking at the possibility of, plugging these loopholes. We look forward to what the government comes up with. But this problem of, time being wasted during prosecution needs to be addressed very, very urgently.
Right. And let's assume that everything falls in place for a particular trial, and let's say the judge is examining the witnesses now. After that, I'm sure that's a long process. I think all the investigating officers have to come, present their statements. The judge will record them, and the defense will put up its own witnesses. And there's always a chance that, many prosecution witnesses have gone hostile. So this is also a regular occurrence, right? Witnesses going hostile in the sense they refuse to cooperate, or they withdraw their statement that they gave before the police in front of the court. So how regular is that? And how, if you're looking at, say, a particular case is attaining finality, so what are the steps involved there? What happens?
Once the trial begins, pretty much the pace of the trial is in the hands of the judge. And it also depends on how many prosecution witnesses the prosecution wants to present. One problem that we have faced, and I'm talking from my experience of over a dozen years in the CBI, is that because the prosecutors are not sharp enough and prepared enough for the case, they will keep repeating the same evidence through different prosecution witnesses. Whereas a well-prepared or a sharp prosecutor will use less number of witnesses to prove the same point before the court. Now, this is as much a question of competence as it is of involvement of the prosecutor in his case. I'm not saying that they are incompetent. What I'm saying is that if they are better prepared with their cases, then instead of examining, let us say, 5 witnesses or 15 witnesses, they could probably end up examining only 3 or 12, thereby saving on time and also saving time of the court. So that is one issue. Once the prosecution completes its case, then the defense has the option of presenting its witnesses. Here again, the normal tactic of the defense lawyer is to have multiple people trying to prove the same point. From the point of view of the defense, it is a time buying exercise, because the more witnesses he examines, the more time will be expended, and the judge does not have time to do look at just one case on a daily basis. So he buys time, and the prosecution's attempt is to reduce the number of witnesses who are to be examined. Once that process is over, then there's what is called written argument, which is given from both the sides, and then it is for the court to deliver its judgment. There are instances where, especially in corruption cases, where cases have dragged on for 15 years or 20 years. On the other side, there are cases of murder or loot or rape where judgments have come within 6 months. So obviously, because in loot or murder or rape, the number of people to be examined is less, the number of documents that have to be proven is less, the volume of the prosecution story is less, and there is, I suppose, some public pressure also that cases should be finalized at an early date. So all that makes for slightly quicker disposal of cases of heinous offense like murder or rape or something like that, as opposed to the document-based cases of corruption or bank frauds.
Right. And since you mentioned category of sexual assault cases, just a bit on that, because the evidentiary standard over there is different, in the sense, if the woman now gives a statement before the court that there was no consent, until the onus is on the defendant to prove otherwise. And there are a couple of other evidentiary safeguards also available in that case, which is to ensure that most survivors of sexual assault are able to come forward and file their cases, and ensure that they can access this process. So would you like to go a little bit of detail into what happens in sexual assault cases? How is it different apart from what I pointed out? And, is the procedure sort of friendly enough for victim survivors to come forward?
In some matters, especially in POCSO cases, some of the evidence is done in camera, so that the victim is able to project her case in a slightly less intimidatory environment. To the extent possible, lady judges or lady magistrates are presiding over such matters. So once again, a slightly less intimidating environment for the victim. These are the steps that the government has prescribed. And it is also important here to mention that the forensic examination of the victim for clothing, etc., is done in a very discreet manner. I am aware that new guidelines have been incorporated into the SOP for the police, and those are meant to make it less humiliating and less intimidating for the victim to make her deposition before the court.
Right. And one more aspect of this whole process that you mentioned is plea bargaining, right? Now, plea bargaining is an invention in criminal law that allows the police to actually settle cases with the accused, if I may put it that way, by showing that the prosecution has a watertight case and there is no way that the accused is going to escape the clutches of law. So might as well the accused may settle for lenient punishment in exchange for accepting his guilt. But this process was introduced a few years back in the Indian context. It is taken off well in, say, the America, so the US or the Europe. But in India, plea bargain is yet to take off. So I have a couple of questions for you. One is, have you come across instances of plea bargaining where it has been successful? And second, why has it not taken off in India?
Yes, there have been cases where we have been able to convince the accused persons to go for plea bargaining, especially in cases where the maximum prescribed punishment is not very much. If the prescribed punishment is 7 years or 5 years or more, the chances that a person will opt for plea bargaining are less in India right now. That is because he feels that he has a better chance of just dragging it and maybe kicking the bucket before the court passes its orders. It is as much question of the judiciary wanting to take this line. I don't think the judiciary is very proactively, or the prosecution is very proactively looking at plea bargaining as a way of disposing of cases in India so far. Specialized agencies like the CBI have been using this. As I said, I have used this, but it is something that is yet to catch on more widely in the Indian context. In any case, let me add that in any case, not too many cases are in the present scenario. Not too many categories of cases are delineated for the pre-bargaining. Only a certain number or certain kinds of cases can be taken up.
Right. So there is indeed scope for improving or maybe extending the scope of cases which can fall under plea bargaining. And also, much like how mediation has gained traction in civil settlements, at least where the courts are today very much interested in ensuring that there is a mediation before the case proceeds to litigation. Maybe there can be some sort of invention and process which makes plea bargaining a critical component of the entire criminal process. So let's move on to an angle which I wanted to explore with you, which is of high profile cases, right? And we have a lot of them in India where, say, politicians or celebrities are involved. And it's a common assumption that, whenever there is such an involvement of high profile people, then more or less the case is going to fail, either due to some sort of partiality on the part of police forces, or some sort of influence that these people can pull in ensuring that the case does not proceed. How has your experience been in handling such kind of cases? What about, say, media trials? Because there's a lot of complaint coming from the police as well as the judiciary that, media trials derail fair and impartial investigation. To what extent is that true? Is it that media is actually influencing the outcomes of cases, or is it that, beyond the noise of media, the investigating authorities and the judges can continue handling the cases?
I think there's no doubt that the hype that is created about a particular case in the media trial, as you call it, impacts the thought processes of the investigator and also of the judges. I can tell you that I've had informal discussions, ongoing cases with people who were judges for those cases, and they've admitted that day in and day out, when the media is talking about a particular case in a particular manner, or pre-deciding what had happened, what could have happened, who could have done it, etc., does in the subconscious mind impact them and influences their thought process about how to deal with matters like bail, also deciding about the quantum of. So that's a human tendency that is bound to happen. If someone is barraged with a particular point of view about a particular case day in and day out, subconsciously he or she will definitely get influenced by it. I believe that the kind of media trial or the media coverage that happens in high-profile cases in our country today needs to be tempered down. I think reporting is one thing, then coming up with opinions and trying to give a particular twist to cases, which often happens. That is not in the best interest of the accused. It is not in the best interest of the case, because then the whole judicial process and the legal process does get impacted. Even though someone will not get impacted, subconsciously it does make it.
Right. And what about involvement of high-profile people?
High-profile cases, definitely the fact that the person is high-profile means that more than anything else, he has the best lawyers to defend him. I think that aspect needs to be kept in mind. It also makes a difference that the benefit of doubt in such cases would be given to the high-profile person during the investigation as opposed to a routine case. These are once again situations where very high level of professional ethics by the police leadership is required. And I would say that there are individual officers who have been able to withstand the pressures of dealing with these cases. Unfortunately, there are many who have not been able to withstand it. But to believe that a person will be framed just because he's high profile, that possibility is less. That he will be given benefit of doubt if he's high profile, that possibility is more.
Right. And one quick question before we end today's chat. That is about police accountability in this process. In the sense, I want to know, there is no guarantee that if I make a complaint to the police that the case is going to get solved. The police does not offer me the guarantee. The state does not offer me the guarantee. It is really up to the police officers to decide whether, I don't know, on basis of seriousness of the offense, its relevance, or maybe some other external pressures to decide whether to investigate and prosecute a particular complaint. So is there any way to improve this? I'm not talking of, say, a guaranteed outcome in every case, that every case is going to be solved by police. Maybe that is impractical. But is there any way to ensure that all cases are dealt with a certain amount of seriousness and properly investigated by the police?
The law provides under Section 155 of the CRPC, I beg your pardon, that the station house officer has to take a call about whether a case which has been reported to him has to be investigated or not investigated. And the thumb rule in that is that if it is a petty matter or not very important matter, something will not have repercussions, etc., then he has the option of putting up a report to the court saying that he does not want to investigate this case. The court can overrule him and ask him to investigate nonetheless, but that happens rarely. In every other case, it is obligated on the police to investigate the matter. Whether each case is investigated with the same vigor, with the same amount of resources put behind it, the answer is no. And why is it no? Because resources are limited and the number of cases is much more than the resources can handle. There are some cases which are done in a routine manner. There are some cases which are important for a variety of reasons and have to be taken up with much more earnestness and with much more resources being put behind them. As a thumb rule, I would say that a case which involves the community or the society at large, as opposed to a case which involves just one individual, the chances are that a case which involves just one individual will probably have to make way for something which has more wider repercussions. For example, a cycle theft or bike theft will not result in as much effort and as much resources being put into it as a murder would, just to give an example.
Right. But I'm not entirely convinced, because I do feel this kind of subjective discretion in the police officers may not ensure the most fair and just system out there. So are there alternatives? If you could imagine this process of, the SHO getting to decide and putting up a report before the court, in your assessment, do you think this is a fair and just system, or do you think we could be doing something better?
Given the resources that the police has right now, and given the fact that the number of cases that are reported to the police are going up almost on a daily basis, especially in urban areas, I am unable to see how this situation can change. It may not be the ideal situation, but that's how it is at the moment.
Right. So we actually come back to that chronic problem of state capacity in public policy.
I think state capacity, not only in terms of numbers, but also in terms of training and related matters of logistics.
Right. So we do come back to state capacity, which is a often recurring theme in any public policy discussion, especially in the Indian context. But thank you for this wonderful discussion, Mr. Ahmad. Found it extremely enlightening on different aspects of criminal justice and crime investigation. So thank you for joining me on this chat on Police Chowki.
Thank you, Shri. Thank you very much.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.